rise. The Court of Appeals Division 1 is now in session.
Thank you. Be seated. Still morning. Good morning. Now's the time set for oral argument in cause number 1CA CV170500, Evelyn Lee Spooner versus the City of Phoenix et al. For your information, we are recording again today as usual. So barring problems with the equipment, which I can't tell you never happens, you should be able to critique the argument today on YouTube in a couple of weeks. Counsel, as is standard, each side will be entitled to 20 minutes. We would ask that you respect that time period. The timer located on the podium will let you know how much time you have left. And for the appellant's benefit, we always advise, if you want to save any of that time for rebuttal, it's up to you to do that, okay? We don't want to take up all your time. We are better advised if you let us know how much time you're wanting to reserve. Ultimately, saving that time is yours. Up to you. We've reviewed the briefs and conferences this morning. We've reviewed the briefs and conferenced the case this morning, so we are well aware of the facts and issues attendant to this argument, and we say that so that you can figure out how you want to set up your argument today. Counsel, when you come to the podium, I would ask that you each state your name and who you represent. And with that, appellant's counsel, it's all yours.
Good morning, Your Honors, and may it please the Court. My name is Greg Zamora with the law firm Debus, Kazan, and Westerhausen, and we speak for the appellant plaintiff, Miss Evelyn Lee Spooner, who's also present in the courtroom, along with Miss Tracy Westerhausen. I am going to reserve 5 minutes of my time for rebuttal. The defendant appellee, Miss Toni Brown, a Phoenix police officer, made two false statements to a Maricopa County grand jury. First, she swore under oath that she interviewed Miss Spooner during her criminal investigation about allegations that Miss Spooner was exploiting a friend of hers whom she had known and befriended for over 30 years, one Miss Mary Basone. Second, Detective Brown swore under oath to that same Maricopa County grand jury that Miss Spooner was present at a probate hearing where the probate court severed Mary's power of attorney, allowing Miss Spooner to act as her attorney. In fact, based primarily on Detective Toni Brown's testimony at that hearing. These false statements, Your Honors, are not discreet. With respect to the first...
Define discreet in the sense you're using it, please.
That it wasn't her hair was blonde, or she was a brunette, or he was 6 feet tall, she was 5 feet tall. This interview that Detective Brown presented to the grand jury was a discussion of a thorough and long conversation that she had with Miss Spooner, where Miss Spooner claimed to describe how Mrs. Basone's health was. She claimed to show, Detective Brown claimed that Miss Spooner showed her a video where a doctor was performing, I think chiropractors call them manipulations, but doing some type of treatment on Mrs. Basone, and Mrs. Basone was saying certain things. Detective Brown also said at the end, she implied to the grand jury that Mrs. Spooner's reasons for doing or not doing certain things wasn't helping her cause in terms of the criminal investigation. That essentially she was implicating herself in some type of wrongdoing or making herself less credible in the eyes of Detective Brown. The second falsehood that she told to the grand jury was that Miss Spooner was present at this probate hearing. Well, Your Honor, this was an emergency probate hearing. It was given without notice, so Miss Spooner could not have known about it. It was done, I believe, under seal, but in any event, Miss Spooner wasn't there. Detective Brown did not simply say that Miss Spooner was present at the probate hearing. Detective Brown said that Miss Spooner, once the court took away her power of attorney, got up and left and yelled, "I'll have my attorney figure this out." None of those two events occurred. It's not anywhere in her police reports. It's not anywhere described in her affidavit.
And counsel, what's the underlying claim in the lawsuit?
The underlying claim, Your Honor, was that Detective Brown conducted a negligent investigation that resulted in damages to Ms. Spooner.
All right, so let's go back to these two misstatements. Were those facts that you were going to use or you intended to use to prove elements of the offense?
Not at trial, Your Honor.
Well, go ahead.
The issue of whether or not we could use her grand jury testimony against her as a basis for our claims was resolved by the trial court, by Judge Ray, in a motion for summary judgment filed by the defendant's City of Phoenix.
And are you challenging that?
I am not challenging that, Your Honor, and I'm not challenging that that Detective Brown is entitled to absolute immunity for her statements made to a grand jury. That case is resolved. That issue is resolved.
So what about your whole difference between state and federal secrecy grand jury proceedings argument? I think there's actually you listed three issues. One of them was whether or not this was an absolute immunity case.
Yes, Your Honor. The Regerberg opinion, which was the federal case that granted absolute immunity to grand jury witnesses, that was based on a number of factors, such as grand jury secrecy, the importance of having complaining witnesses come forward and be truthful and honest, and not fear that in every case that they testify that they're going to be subject to some civil lawsuit later on.
But bottom line, you agree that absolute immunity applies in this case?
Yes, Your Honor.
So we don't really have to explore the depths of that doctrine in your 15 minutes.
Correct, Your Honor.
Okay. This case was submitted to the jury on a gross negligence theory, right? Because gross negligence would overcome qualified immunity.
Yes, Your Honor.
Correct?
Yes,
okay.
Your Honor.
And the jury found adverse to your client on that claim.
Yes, Your Honor.
Okay. So when we boil it down, what we're really talking about is the scope of immunity for a merely negligent investigation.
Yes, Your Honor.
Okay. I admit that it seems counterintuitive when you have evidence of potentially really bad willful conduct to talk about mere negligence. But I think we have to because the gross negligence was already submitted to the jury and you don't object to that. So when we talk about mere negligence and we're talking about unreasonable conduct, isn't that the very definition of what qualified immunity covers?
Your Honor, we take issue with whether or not Detective Brown was entitled to qualified immunity for her police investigation. There is no case in Arizona that has held that. The trial court in declining to instruct the jury on the mere negligence claim found that Landeros, which was a Division II case, that Landeros set the standard and that Landeros held that officers are entitled to qualified immunity for their police investigations. The Division I Court of Appeals in Hutchinson v. City of Phoenix recognized or examined Landeros, and it said that portion of the Landeros opinion that held that officers are entitled to qualified immunity was dictum, that it was not binding.
Okay, but now let's then talk about whether officers are entitled to qualified immunity. You would agree, I take it, that officers are entitled to qualified immunity for some things, yes? Driving, for example. Or not?
No, Your Honor.
Okay, so you can bring a simple red car, blue car case or white car, black car case against a police officer.
Yes, Your Honor.
Okay. Is there any function that a police officer performs that is entitled to qualified immunity in your view?
Well, in this case, Your Honor,
I'm asking a broader question. Any function?
No, Your Honor, I don't.
Okay. The ramifications of that seem stark because I'm not sure who you would define as the potential class of plaintiffs. Obviously, somebody falsely accused would be a logical plaintiff. But what about a victim whose case is never solved because of missteps by the police? Can they sue?
If there is some evidence, well, yes, Your Honor, if there is some evidence that the officer failed to act as a reasonable officer under the circumstances,
Well,
I think.
I guess hindsight is 20/20, and I think one of the reasons that we'll hear qualified immunity is appropriate is it's very difficult to tell in the moment what a reasonable officer would have done because we don't yet know the results of that conduct. We know what lawful conduct would be. We know at some extreme bounds what imprudent conduct would be. But what's the reasonable step in conducting an investigation? That's an art as much as it is a procedure.
Yes, it is, Your Honor. But the Supreme Court in Ryan distinguished between. It held that public officials are held to the same standard of care as any private citizen. The court just did away with this public-private doctrine as established in Messingale before that, and that in Arizona, when an officer fails to act reasonably under the circumstances, that they shall face, or they should face, at least some civil liability.
But you agree that some officers are entitled to qualified immunity?
Under certain circumstances, I suppose, yes, an officer. I think there are some, and I can't think off the top of my head or list them right now, but there are some statutory qualified immunity benefits.
Isn't there a statute?
There is a statute, but it doesn't name
You're talking
police
about
investigation.
common law qualified immunity, because there's a statute, and it's a pretty in-depth statute that provides for qualified immunity.
Yes, Your Honor.
You concede that?
Yes.
If an elections official fails to bring power cables to the polling place and no one can vote, does the election official have qualified immunity? Just an innocent mistake, just forgot to bring the cables.
No, I would say no, Your Honor. If there is some proof that the elections official did not act as a reasonable election official would under the circumstances, I think that
you don't need that if, because that's failure to act reasonably is the element of the claim. Qualified immunity exists as a matter of law, or it doesn't. So it sounds like you're. I don't mean to put words in your mouth, but it sounds like you might be arguing for the abolition of qualified immunity for official conduct across the board.
No, Your Honor. I think that if there is qualified immunity, that it's the legislature's role to define what, as a matter of public policy, they want to provide officers with in terms of what they shall not face for certain conduct that they will not face civil claims for.
What if the legislature says, you know what, we're going to let all that exists on this day, the common law immunity doctrines remain in place, and we're going to expand on it? That's the legislature talking. Does that mean what they say, meaning the common law immunity doctrines that were there remain?
Yes, Your Honor, and I think that this statute in question here does say that, but
Right.
there is no the case that the trial court relied on, Landeros, did not hold. It was not binding on the court that officers during an investigation have qualified immunity, and that they are there then subject to gross negligence.
Well, let's put Landeros and the common law aside, okay? You're saying to me we have a statute that provides for qualified immunity in the state of Arizona, correct?
Yes, Your Honor.
And it says that all common law immunity doctrines that existed before today remain in place. Is that accurate?
Yes, Your Honor. I think the actual language is it does not abrogate or does not take away.
Okay.
But yes.
But
I
yet,
report.
you're asking us to say, you know what, it did abrogate it. It existed before. We had this common law doctrine of qualified immunity. We have a statute, and poof, poof, it's gone. What's your authority looking to the legislature, looking to the statutes, to argue that the common law qualified immunity doctrine no longer exists?
Your Honor, the common law qualified immunity doctrine does exist, and it exists as enumerated in that statute. Our argument is that because the legislature did not include that officers who are investigating crimes shall be subject or shall be entitled to qualified immunity, that because the legislature intentionally did not include it, and because there is no case that's precisely on point in terms of its holding, that it doesn't exist. And therefore, the Ryan Doctrine, which says that public officials are held to the same standard of care as any other individual in society, applies here.
And that Ryan is a court case, a common law case?
Is an Arizona Supreme Court case, yes, Your Honor.
And that, even though we have a statute here that says we're not abrogating anything, you're pointing to a Supreme Court common law authority as saying that statute, it's not specific enough, or
No, Your Honor. I'm pointing to Ryan to show, well, yes, to show that the statute lists several factors for which, or several lists conduct by public officials for which they are entitled to qualified immunity. It also says that it does not change the common law rights of public officials in terms of what they are entitled to as far as qualified immunity is concerned. I'm arguing that Ryan overruled the common law, overruled this public-private distinction that gave officers qualified immunity.
So Ryan abolished qualified immunity. That's your argument.
Yes, Your Honor. Well, it did away with the public-private doctrine of saying that public officials are entitled automatically to qualified immunity. And Your Honors, I have 5 minutes.
Other than Ryan, there's been nothing since Ryan that addressed this issue.
No, there has, Your Honor. And in fact, I think the Court of Appeals just released an opinion, I think yesterday, where the claims were negligent police investigation. The case turned on something else.
The case turned on duty. That was not an immunity case.
I agree with you, Your Honor. But I'm saying that there are still claims being made against police officers for their negligent investigation. And I think one of the cases that we cited in our briefs was Austin v. City of Scottsdale, where it was a 911 operator that whether or not it turned on whether or not the 911 officer provided certain information in a reasonable amount of time, and then the City of Phoenix, or Hutchinson versus the City of Phoenix, which addressed Landeros right on the screws. But Your Honor, I've got 4 minutes left. I'm going to reserve the rest of my time for rebuttal.
Thanks.
Good morning, Your Honors, and may it please the Court. My name is Melissa Iyer-Julian, and I represent the defendant's Detective Tony Brown in the City of Phoenix.
You want to jump right to our issue that we've been pounding on pretty hard here?
Well, I was going to start with the impeachment issue, but I can tell that the issue that you, Mr. Zamora was talking about with you was the second issue, so I will address that first at the panel's preference. I think that it's important, though, to clarify the history of both the public-private duty doctrine that developed and then was subsequently eradicated from Massengale, Stone, and eventually Ryan, then the legislature's enactment of the Tort Claims Act in 1984, as well as the preservation of common law immunities under both of those cases. So his argument, I think he said, was that Ryan abolished immunity because of its elimination of the public-private duty. That isn't actually true. If you read the Ryan versus State case, it does eliminate the public-private duty, but it says, and I quote, "In electing to treat the state like a private litigant, we must hasten to point out that certain areas of immunity must remain." And it then went on to cite with approval the Supreme Court's decision that same year in Grimm versus the Board of Paroles and Pardons that gave qualified immunity to pardon the board officials that were accused of having negligently released a prisoner on parole. So the Ryan case itself, while it eliminated this public-private sort of general proposition that there was no private individual duty, didn't eliminate or abolish the common law immunities that apply to executive officials, when they're engaged in discretionary as opposed to ministerial types of conduct. That's been reiterated time and again since the passage of Ryan. For instance, in the court's decision, the Supreme Court's decision in Chamberlain versus Mathis, the court specifically stated the preserved common law rule that executives who engage in discretionary or conduct that requires some form or exercise of judgment still retain a form of qualified immunity that imposes upon them not a standard of ordinary negligence but a standard of gross negligence. This court has continued to apply that to public officials, including police officers. For example, in Portnova versus Wilkinson, the Supreme Court reiterated that police officers are entitled to conditional immunity when they're engaged in conduct that falls within the scope of their duties. Investigative conduct, choosing what witnesses to interview, choosing what documents to review, choosing what evidence to provide to the grand jury prosecutor in support of a recommendation in favor of prosecution, choosing what information to include in departmental reports, providing grand jury testimony. All of these are things that were attacked as having been wrongful in the course of Detective Brown's investigation. All of those activities require judgment. They require the exercise of a detective's discretion and fall within...
Or the grand jury is specific in that regard. Is that correct? Is that what you're saying?
Well, it certainly goes to the heart of the plaintiff's case, and that's another thing I wanted to clarify. When asked what is the crux of your case or what is the basis for your claim, today it was articulated as, negligent investigation. But if you look at the first page of the plaintiff's opening brief, the very first sentence says, before a grand jury, Detective Tony Brown of the Phoenix Police Department testified falsely on multiple issues regarding her investigation of Evelyn Lee Spooner for alleged elder abuse. The alleged victim was Ms. Spooner's longtime friend, Mary Bissone, and this is the important part. As a result of that false testimony, the grand jury indicted Mrs. Spooner for theft. That was the basis for their claim, was that the indictment was tied to the grand jury testimony, and that testimony is immunized.
I think the plaintiff's saying that's not why we're introducing that testimony, and we can deal with that with a limiting instruction. Why isn't that true?
Well, I think it's not true based upon the record in the case. Beginning with the complaint and the first amended complaint, I believe I counted 15 paragraphs in the first amended complaint, at least, that were devoted to reciting the grand jury testimony as a basis for the plaintiff's remaining state law claims. Then, if you go to the joint pretrial statement, which was filed before the court ruled on the motion in limine excluding the immunized testimony, there are three, and that's at the record, item number 123. There are 3 full pages that the plaintiff devotes describing the grand jury testimony under the section entitled Evidence Material to the Plaintiff's Claims. This was always evidence presented as material to the plaintiff's claims. It was only after the court said, based upon immunity, you can't use this evidence as material to your claims, that the plaintiff then repurposed it or relabeled it as impeachment evidence.
Right. Well, litigation is a road. It's a path. Right. Things happen and you have to adapt as an attorney, as a counsel. And so here we have the adaptation, the adapting, and then we have going back to the limiting instruction. Why isn't the limiting instruction? I mean, they're used all the time. Why isn't it sufficient in this case to get over any 403 issue?
Well, in this case, I don't think it would have been sufficient, and I think that's the decision of whether or not to give a limiting instruction, as with the analysis of admitting or excluding evidence, is subject to the trial court's discretion. But before deciding whether to admit the evidence with a limiting instruction or exclude it, the trial court followed the proper analysis it was supposed to, which is to look at the probative value of the evidence versus the danger of unfair prejudice.
I'm sorry, if you were finished with your answer, I wanted to shift you to a different topic.
I'd rather answer your question.
Okay. Let's say that your reading of Chamberlain v. Mathis is correct. Okay. And there is some generalized qualified immunity for negligence. This case was submitted to the jury on a gross negligence theory, which presumably means that the court found that there was sufficient evidence from which a jury could find that qualified immunity, if it applied, was defeated. Correct?
Correct.
Okay.
The judge did deny a motion for directed verdict on the gross negligence claim.
Given that, let's say that as a matter of law, qualified immunity exists under Chamberlain, why hasn't it been defeated in this case? In other words, why shouldn't the negligence case have been submitted to the jury because of sufficient evidence of gross negligence to defeat qualified immunity?
I don't think the mere fact that there is evidence to defeat or evidence that prevents a directed verdict on the issue of gross negligence as far as a breach of the standard of care eliminates immunity. I think the question is, what does the standard of care become if an officer has qualified immunity? And under Chamberlain, the standard becomes a reckless disregard for rights, which in essence is a gross negligence standard.
Right, but there was not only an allegation of gross negligence here, there was also sufficient evidence to get past the jury. If we were here on summary judgment, right, and you one side says this negligence case should be dismissed under qualified immunity, or should be ended under qualified immunity because it's just a negligence case, and as a matter of law we have qualified immunity. The response would have been, well, wait a second, we've got evidence here of gross negligence, really bad evidence of gross negligence, and the motion would be denied. Here, at trial, there was evidence of gross negligence that was submitted to the jury. Rule 50 motions denied. Why isn't that enough to preclude judgment as a matter of law on the negligence claim?
Because I think the issue is when qualified immunity exists for an official based upon the type of conduct that's placed at issue in the case, the mere fact that there exist facts to support a finding of gross negligence and opposing, obviously there was, and on appeal, the record should be viewed in the light most favorable to the finding that there was no gross negligence. But when there's evidence on both sides, then it becomes an issue that it should be submitted to the jury. I think that's what the case
wasn't submitted to the jury, right? I mean,
precisely.
That's the problem that I'm asking you about. Wouldn't the correct course have been to say, yes, qualified immunity exists as a matter of law, and you, defendant, are entitled to at least consideration of qualified immunity, but there are enough facts here to justify submitting to the jury the question whether that immunity has been defeated by your allegedly grossly negligent conduct.
And I think that's exactly what happened, and it was the proper result. The application of immunity in this context, at least my understanding, my review of the case law, which I know that there's been an attack on Landeros as not being binding on this court, but what it does say is for conduct that falls within the scope of a police officer's investigative duties, they are not subject to a standard of ordinary negligence. They're subject to a standard of gross negligence.
I guess that's the same as saying, though, that qualified immunity exists. My question is, unless I badly misunderstand the procedural history, the trial court granted a judgment as a matter of law on the issue of negligence. Is that correct?
Yeah, I think yes, essentially
Okay.
it was.
Okay, so if the trial court granted a motion for judgment as a matter of law on simple negligence, but denied one on gross negligence, how can those rulings be reconciled?
I think they're reconciled by the fact that, and the reason for the granting of the motion for a directed verdict on the ordinary negligence claim is because Arizona courts don't recognize an ordinary negligence claim for investigative conduct.
Of course
they have
do.
found that
there's no. I'm sorry to interrupt you, but I think that we may be on different semantic tracks. I think it's fair to say, tell me if I'm wrong, that Arizona courts do recognize a claim for simple negligence, but they defeat it because of the existence of qualified immunity.
Which raises the standard for proceeding to a jury to gross negligence.
Okay, so we're speaking the same language. I guess my question is, if the court found evidence of gross negligence sufficient to survive a Rule 50 motion, how can it then grant the Rule 50 motion on simple negligence?
And I think that the existence of immunity doesn't provide for the presentation of an ordinary negligence claim to the jury as a matter of law. In order to present the claim to the jury and get a verdict of liability, the plaintiff has to meet the heightened standard of gross negligence.
Which this plaintiff did.
No, the verdict was in favor of the defense.
No, but for purposes of the Rule 50 motion, which is all that we can really consider on appeal, this plaintiff met the standard.
For purposes of the Rule 50 motion, the trial court decided that the plaintiff had presented a material dispute of fact as to whether there was a breach of the standard of care, defining the standard of care as gross negligence.
So what's the difference then between the two claims?
The difference between the ordinary negligence versus gross negligence?
And let me make, that question was unclear. What is the difference between the conduct at issue in the simple negligence claim versus the gross negligence claim?
Well, I think the difference is the standard that the trial court used in instructing the jury, and that the Supreme Court articulated in Chamberlain, which is a willful or reckless disregard for the harm that may come as a result of one's conduct, as opposed to simply a breach of the standard of care of a reasonably prudent person in the same or similar circumstances.
I'm asking the question badly. Let me try this again. Was the gross negligence case was submitted to the jury? Was there any conduct at issue in the simple negligence case that could not have been considered as part of the gross negligence claim?
I don't know that I quite understand, but I think that the evidence, I guess the evidence that's relevant to a breach of the standard of care for ordinary negligence would most likely be construed as relevant or admissible to the breach of, because the jury at that point is considering the weight of the evidence overall as opposed to
what I'm
one
getting
piece of
at
evidence or the
is
other.
the only difference between these two claims in this case the scienter requirement, or were there other differences between those two claims on this record?
I believe the only difference really is the scienter requirement, and it's precisely because the cases have held that when, and I would also point out to the court that since the decision in Ryan and since the passage of the Tort Claims Act, including 12.820.05, which preserves common law immunities just like Ryan did, this court has applied common law, a heightened standard for other types of officials engaged in investigative conduct. Most recently in Randall versus Maricopa County, this court applied the common law sort of qualified immunity to a doctor who was engaged in conducting a medical examination, a death investigation. That's investigative conduct for which the court has preserved qualified immunity and applied the heightened gross negligence standard.
But when the court dismissed the negligence claim, was it doing so based upon the record and whether, or was it doing it as a matter of law, that Arizona law requires that under qualified immunity you either need clearly established violating or recklessness? Was that a legal decision?
Yes, it was a legal decision. I think that the application of a heightened standard to public officials based upon a conditional or qualified immunity is always a question of law that the court has to resolve.
And if the court went forward and considered the negligence claim, would that have been what, an error, a legal error?
It would have been, because it would have been subjecting officers engaged in discretionary conduct to a claim of ordinary negligence, which the court has held is not appropriate. If an officer is going to be brought into court and sued in connection with conduct that requires them to exercise discretionary decisions, and in the case of detectives, the most discretion they exercise is with respect to their investigative conduct, then in order to sue that officer the plaintiff has to meet the heightened standard of gross negligence. That's what.
And then, so to distill your argument here, you would say on this record that the negligence and gross negligence claims were substantively identical except for the scienter requirement, and because the plaintiff got to present gross negligence, qualified immunity would say that negligence is off the table. Because we're not really talking about two different bodies of conduct, we're talking about one body of conduct with two different arguable states of mind.
Right. A different standard of care that's applicable because this case involves a public executive officer engaged in discretionary conduct. And you asked a bit about the concept of a hypothetical officer forgetting to bring a cord or bringing a cord down to the election polling place. That's precisely the kind of conduct that the Supreme Court addressed and distinguished as ministerial in Chamberlain versus Mathis. The court said things like moving furniture or driving a car are not the types of conduct that we require this heightened standard of care for. But discretionary decisions like investigative conduct, whether that's by a prosecutor who enjoys at least qualified immunity when prosecutors engage in investigative police-like activities, this court has recognized that they're entitled to qualified immunity for that investigative conduct.
Is testimony before a grand jury, truthful or untruthful testimony before a grand jury, does that elevate it to gross negligence?
Well, actually, it couldn't, because the testimony before the grand jury, as the appellant has conceded, was inadmissible for substantive purposes because of the separate and absolute immunity that grand jury witnesses enjoy. And that's a point.
A different issue than the public sector immunity.
Yes, this case involved the two different kinds of immunity. One, the absolute witness immunity that Detective Brown has in connection with her testimony before the grand jury, as well as a qualified form of immunity requiring the heightened gross negligence standard for the attacks on her investigative activities. And both of those immunities were appropriately applied in connection with the admission of evidence, as well as the jury instructions, to which, at least the jury instruction on gross negligence, the plaintiff did not object to. So really, the question here today is, did the trial court, number one, abuse its discretion in admitting the impeachment evidence, clearly based upon the record of the case, and, as pointed out in our brief, the way in which counsel argued this case, he was still permitted to impeach Detective Brown utilizing her prior affidavits, the search warrant affidavits. He was allowed to bring in the criminal defense attorney, Tom Hensey, who testified to the litany of things. And while it was framed as being withheld from the grand jury as opposed to testifying before the grand jury, all of those items of evidence were introduced. And in his closing argument, his argument to the jury was, she lied to secure this indictment, and for that reason you should hold her liable. Had he been permitted to utilize the grand jury testimony in addition to all of the other testimony, the trial court was absolutely correct in finding that would have been unfairly prejudicial given the nature and the way in which the plaintiff framed his claim.
Although, would you concede that if the trial court had said, I'm going to allow the impeachment but with a limiting instruction, that too would have been an act of a valid exercise of discretion?
I disagree, actually, in this case, that would have been a valid exercise of discretion, given the nature of the way this evidence was presented.
I can never get anyone to admit that discretion runs both ways.
I think, actually, in the prior argument, someone did. But in this case, I'd probably be arguing in front of you that it was because the admission of this evidence would have been prejudicial, which is why the trial court properly excluded it.
Find the prejudice for me, please, quickly.
Prejudice is when
The prejudice in this case. What would have been the prejudice?
The prejudice is that this evidence, the crux of the plaintiff's claim was that my client lied in order to secure an indictment that eventually led to her arrest. If the jury was presented with grand jury testimony, it would be virtually impossible for them to distinguish the purposes for which they could use that testimony when they're being told the claim is that she lied to secure this indictment. And so the danger of unfair prejudice when you have evidence that serves both the purpose of demonstrating liability as well as the impeachment purpose demonstrates a far greater risk of unfair prejudice, and I think that prejudice certainly would have been experienced here.
Thank you.
sure you have much to say, but let me ask you just whether you wish to dispute the characterization of the negligence and gross negligence cases as involving fundamentally the same body of conduct, but with different levels of scienter.
No, Your Honor, I don't. I think that the record
That's
shows.
a fair characterization?
Yes, Your Honor.
Okay, I won't take more of your time with that issue.
Your Honor, there's one court case that this court should focus attention on in terms of the use of the grand jury for impeachment, and that's Marshall v. Randall. It's the only case in the country that we've been able to find that says use of grand jury testimony for impeachment purposes does not violate the witness's absolute immunity. Your Honor, we use otherwise inadmissible evidence for other purposes all the time in trial work. In criminal cases, a defendant's confession, which is excluded under the Miranda or under the Fifth Amendment right against self-incrimination, which cannot be used at trial, may be admitted if the defendant gets on the stand and says something that's inconsistent with his testimony there. I want to direct the court to one trial day and one line of questioning from Mr. Debus, who was the trial lawyer in this case, where he was asking Detective Tony Brown, and he asked her specifically, I think it's day 16, page 197. He asks her, "Did you interview Lee Spooner?" Detective Tony Brown says no. "Do you know of anyone else who interviewed Lee Spooner?" She said, "Not that I'm aware of." Either she interviewed her or she didn't interview her. Both those facts cannot be true. One of those items of evidence was false. And Mr. Debus approached the trial court and said, Your Honor, I'd like to admit her prior testimony as inconsistent with her testimony here before you today.
You know, counsel, in your brief, I don't know if you use the word evil, but you have some adjectives in describing the detective here. Are you saying that there was some pecuniary motive, or was this just bad detective work in your mind? I mean, those are different things.
No, Your Honor. In fact, I don't recall if we necessarily characterized the detective as evil. I think it was just whether it was a result of gross incompetence, whether it was a result of just, I'm sorry to say, but just laziness. I don't know. I can't get into Detective Tony Brown's mind. I can tell you what she did. She did not pass on incredibly important information from a doctor who had examined Mrs. Bissoni in Florida, who said that she was capable of deciding where she wanted to live. She did not pass along information that before she left Florida, Mrs. Bissoni had met with a lawyer there who specializes in legal issues concerning the elderly of our population, that he met with her personally, and that he assured himself that Mrs. Bissoni wanted Lee Spooner to act on her behalf. She omitted that from very important parts of her investigation. I will say this. The court multiple times throughout the trial instructed the jury, gave them limiting instructions in terms of hearsay with respect to Detective Brown's police reports. He told them time and time again, you are not to take this evidence for the truth of the matter, but to consider it for the effect on Tony Brown and her deciding what she wanted to do in terms of her investigation. He gave it over and over again at the request of Mr. Debus. When Judge Weinsberg earlier said that litigation is like a road, well, a trial is like a road. This court at the very beginning of trial held that her grand jury testimony was not admissible for any purpose. But when confronted at trial with a statement that was diametrically opposed, 180 degrees different, and reminded of that by bench conference, the court held on to its prior ruling, and unfortunately the jury, who is the real body that is to determine credibility, was unable to hear that other statement from Detective Tony Brown. And I'm out of time, Your Honors. Thank you.
Thank you. We do enjoy oral argument. We've heard some good stuff today. Thank you for that. We're going to take the matter under advisement at this time. Thank you again. We will adjourn.